Okay, so we are back in continuing with employment law in Chapter 12. I do have Title VII on the screen. The chapter is actually a bit more broad than Title VII, but that's where we're going to start because it is the kind of cornerstone or central piece of litigation as it relates to employment discrimination, which is the title for this chapter. All right. So let's start with a brief discussion of the Equal Employment Opportunity Commission, the EEOC. And so you want to think of the EEOC as it is a federal organization that is related to the Department of Labor, but has its own budget, separate item. Um, and really, it's the gatekeeper to everything in this chapter. All right. If you've ever been in a situation where you had an employment relationship where you wanted to sue, you know that the EEOC is the gatekeeper to that. You can't just sue an employer. You have to file a claim, make a report to the EEOC, and they will investigate. And the EEOC actually has a right to take your case take the case up on your behalf and sue your employer on your behalf. Now that doesn't happen often. In fact, the majority of claims submitted to the EEOC they review. They do keep detailed records and statistics, but typically what will happen is the EEOC will decline to take the case and then issue what we refer to as a right to sue letter, right? So if you ever meet with an attorney and say, I want to sue my employer, that's going to be their first question is, do you have the right to sue letter from the EEOC? And if the answer is no, they probably will help you draft the EEOC complaint, and then they'll wait for that to happen. Okay? So the question is, what types of cases does the EEOC generally take up? Keep in mind it is a federal agency and they do have budgetary limitations. So the cases that they take up are ones where they find established patterns, usually relating to a single employer or in broader cases a specific industry. But more and more it's really just there's a pattern of cases related to a single employer. And the reality is that most employees, even if they have a claim that's actionable, are not going to sue once the relationship terminates. The employment relationship is terminated. And so the EEOC serves as a conduit when there's a pattern of whatever, discrimination, harassment, that is apparent from one particular employer, and the EEOC will threaten to sue. Typically, they'll just ask for a specified action, right? And the employer can acquiesce and agree, counter and negotiate, or flat out refuse, in which case the EEOC would sue them civilly in court. All right, and so we do know that class action lawsuits are not available for employers. So you can't get with, or I should say employees, you can't get with former employees and sue as a class against your former employer, right? And of course, class is when plaintiffs with similar claims consolidate their claims and sue collectively. That's not available for former employees or current employees. However, the EEOC can group similar claims. For instance, if there are 6 sexual harassment claims that the EEOC has and the EEOC decides to sue, they can group those together, right? But the individuals themselves couldn't form a class. All right. So under Title VII, there are 2 broad categories of discrimination, and generally they're intentional and unintentional. the technical term is disparate treatment for the intentional. All right. And this means that the employer has discriminated on one of the federally protected classes, and we see those here: race, color, religion, national origin, sex, age if over 40. In other words, age discrimination under 40 is legal. Disability, and our veteran status. And veteran status is a bit narrow. It actually is military service. All right. And so disparate treatment, it's actually, we have an example here. So members of a certain group must take a literacy test, and I'm at the bottom of the slide here. Must take a literacy test as a prerequisite for employment. All right. So that could be women have to take a literacy test, or certain minority groups have to take a literacy test that you're not subjecting other members from majority classes to. And that's an example of disparate treatment. It's a rule that all you have to do is read it, right? If you put it in black and white, it's discriminatory. That's disparate treatment. All right. Well, when these cases get to court, what do they look like? I like to think of this as your ping pong match because they go back and forth. Employment litigation it's a long process, it's cumbersome, and it's expensive for this reason. You may recall from 2080, the litigation process starts with the plaintiff, and the plaintiff's job in litigation is to make their case, right? In a civil case, show evidence, demonstrate evidence that makes it more likely than not, or to use the legal term, by preponderance of the evidence, that the plaintiff is entitled to some sort of relief. Well, in employment law, cases are a bit more complicated than that, in that so here's the case progression. All right. Plaintiff must make the prima facie case, all right, which means proving that the plaintiff, the employee or ex-employee, was part of a protected class. It could be a member of a certain race, it could be female, it could be a member of a certain religion or national origin. All right, membership in a protected class. You were qualified for the job you applied for, or promotion that you were passed up for, and that the opportunity went to someone who was not a member of the protected class. Right? And that's the prima facie case. And it creates a presumption of discrimination. All right. And the reason I'm calling this a ping pong case is because the ping pong ball has been returned, and now the defense has to articulate a legal reason for the action that was taken. You know, it could be, well, this person had this experience on their resume and we found that valuable, right? But once the defendant has done that, articulated a legal reason for the action, the purportedly discriminatory action, the ping pong ball has been returned, right? And now it's back on the plaintiff. And the plaintiff has to tear apart that legal reason and demonstrate that it's merely pretext, right? And if any point in this ping pong match, if you miss the ball, you're going to lose the case. And so that's how intentional discrimination cases work under Title VII. Okay. Unintentional cases, unintentional discrimination. So this is not disparate treatment, but disparate impact. All right. This occurs when there's a policy or procedure that is racially neutral or let me just say neutral, because race is just one protected class that is neutral on its face, but tends to adversely impact one particular class or group at a higher rate than other parties, than the other groups. All right. These are tougher cases to make because you need data to show this. All right. And so it says assembly line workers must take a math test. Members of a certain protected class perform poorly on that test. All right. So let's just say that it's an assembly line job. Minorities aren't doing well on the math test, and as a result, the rate of hire, and that's why I mentioned the data. So the rate of hire for minority applicants, assembly line workers, is lower, and it's because of the math test. So then in that case, the burden shifts to the employer to show that the math test is relevant and required to be a good assembly line worker, right? And if the company would be able to show that, then the procedure would be valid, despite the fact that it has a disparate impact. If they are not able to demonstrate that, well, it would be actionable, right? And the minority groups may have a claim for discrimination.